Well, in automobile accidents in New York State is controlled by the no-fault law. And the legislature, in its wisdom, came up with the no-fault law back in the 1970s. Prior to having the no-fault law, when you were in an automobile accident, and let's say you got hit by somebody in the rear and you were hurt a little bit. You went to the hospital, you went a few visits to the doctor, and you didn't have insurance coverage for that because no one did, and you didn't have private medical coverage. What would happen then is that you say, you know what, I'm out $500. It wasn't my fault. I'm going to sue this person. And by the time that lawsuit starts, they're not going to just sue for $500. Some unethical lawyers would say, well, we're going to sue for $1 million. But really what bothered you was you were out $500. So what the legislature decided was that we're going to stop these little lawsuits that shouldn't be. And we're going to make sure that everybody who drives a car has insurance. And no matter whose fault it is, if you're hit in the rear by somebody else, a drunk driver, your car insurance will pay your medical bills. And his or her car insurance will pay their medical bills. That's why they use the term no fault. It's not a matter of fault. Because in the old days, you'd say, well, you went through the light. No, you went through the light, and no one's going to pay anything. So when they did that, it took care of paying the medical bills, but then they put a provision in there. And the provision was that you cannot bring a suit unless you have a serious injury, because they wanted to stop these small cases. And that's when they came up with the requirements that you need to have a fracture, a dismemberment, a scarring, death, out of work 90 out of 180 days, permanent partial disability, loss of a fetus. You have to, as your trial lawyer, I must prove that you fit into one of those categories before the jury can determine what you receive for your pain and suffering. If we could prove that you fill into one of those categories, and this is how the question goes to the jury, has the plaintiff proven that he was out of work 90 out of 180 days because of this injury? And if the jury says yes, then you have a serious injury. Then they go on to question 2, what, if anything, are you going to award for past pain and suffering, which means pain and suffering from the date of the accident to the date of the trial? And what, if anything, are you going to award for future pain and suffering, which is pain and suffering from the date of the trial to the day the person dies?